So in this area of pregnancy discrimination then, is there one that's more favourable than the other, perhaps?
It depends on a number of factors, but one that immediately springs to my mind is what remedies are available. And we haven't necessarily got on to the topic of adverse action, but it does follow, because one of the reasons why somebody can take adverse action, which is basically any unfavourable treatment, it is prescribed and defined in the Act, the Fair Work Act, but it does capture also conduct which is unfavourable to a person who is pregnant.
Can you give us an example of what would be unfavourable?
Unfavourable in the sense that somebody's employment might be terminated, their terms and conditions might be altered either at the time that they announce their pregnancy or on a return to work. They may be overlooked for a promotion or denied some form of perhaps exposure to a management course or something which is favourable and would advance them in their employment.
You've just raised an interesting point in terms of promotion. I understand that you have to be treated equally, no matter what your characteristics, your personality, your features are, but when it comes to promotion and you are pregnant and about to go on maternity leave, what kind of effects does that have? Will there be discrimination in that circumstance?
It could potentially be. It's obviously more difficult though, because a business needs to be able to obviously continue, but it's being treated in a manner which is has parallels with other people in the organisation. So in that respect, obviously it could be a difficulty for somebody if they're about to go on leave, but it's making sure that that's not the main reason why they're being overlooked, and reasonably accommodating them on their return. But in terms of the actual obligation, it's a like role that you're being returned to. So in that sense, perhaps the promotion is not such a good fit.
Right.
And I think that Catherine touched on a good point there where she talked about the reason, because sometimes what it actually comes down to, or what it does come down to in an adverse action claim, is what is the reason for the adverse action that's been taken. So what is the reason in the mind of the person, the decision maker at the workplace, for taking that action? So in that case, the example that you gave, it could be that the reason that she wasn't given a promotion is because there was somebody who was more meritorious in their standards and their performance. So, and if that's the only reason, then that's fine. But if one of the reasons is that she was pregnant, then the employer's got some trouble.
So in that case, what if you feel as though that reason wasn't genuine? What could you do then?
Sure. Well, a lot of the time it's difficult for the employee because they haven't got access to the information, and if they ask the decision maker at the workplace, well, why did they make the decision, then we know what they're going to say is because they didn't deserve the promotion. But fortunately, the law in this area has turned that around a little bit by making what's called an onus of proof on the employer to disprove that they took the action for a prohibited reason.
So what kind of things would they use in that circumstances to prove that they
file notes and records and documentation. So that's why for an employer, the really key thing is to record down, minutes of meetings and what was said at meetings and what steps have been taken and why. Really good record keeping is the key.
And likewise for employees, it's really important to keep records. So if you start to suspect that you're being discriminated against because of pregnancy or any other unlawful reason, keep a diary, keep a handwritten diary and date each entry. Keep any other records that you can that might support a case against your employer, and also try and encourage any witnesses to support you.
So Paul, where does unfair dismissal come into this? We have covered that in the past, and can you give us just a brief refresher of that?
Sure. Well, what unfair dismissal in a really brief summary really means is that either there's no valid reason for the termination, or there's procedural steps that haven't been taken correctly, such as being given notice and or an opportunity to improve. So, as you can see by that, if there's no valid reason, for example, that they were discriminated against on the basis of them being pregnant, then that wouldn't be a valid reason, and therefore would make it more likely that that employee would succeed in a claim.
Right. So there are different benefits to each sort of claim, adverse action or unfair dismissal?
I think
Is there one that you would try first and then before the other?
I think
Or can you
it
run them
really
up?
depends on the character of the complaint, and I think if you are confident that you have the features of a discrimination case in the pure sense or in the true sense, then certainly I would be more inclined to run it as a discrimination case. But the unfair dismissal is obviously very helpful where you've got a dismissal that is what you certainly consider to be unfair, harsh, unjust or unreasonable. And as Paul said, there'll be something that has gone wrong either in the process or in the substantive reason or in both in a lot of cases. But they are usually not so concerned with the motive is obviously relevant or might be partly relevant, but the discriminatory aspect of it is usually not at the fore, and those types of cases do lend themselves to either an adverse action or an unfair, not an unfair dismissal, a discrimination proceeding. And in terms of the remedy or relief that you can achieve from a discrimination case, it's certainly more favourable.
What are some of the remedies available?
Well, there is compensation, and that could be for past economic loss. So a good example being if somebody is treated unfavourably because of their pregnancy and is told to go off work early, or their hours are reduced, and you'll have a claim for economic loss in that sense, the hours that are lost, the income that's lost. There might be a dismissal, which means that you can successfully argue that but for that dismissal you would have continued on in that role for a period of time.
Is there any opportunity for you to get back into that workplace?
There could be. That could be an order that a court makes, although not made lightly, I should add. Courts and the Commission are usually reluctant to impose those types of orders on an employer, but it has happened. So you could
Are there certain types of circumstances in which that's suitable?
Really, I mean, the basic, or the limit is where a court or a commission is satisfied that everything is broken down to the point where it's unwise, it's unsafe to return somebody. But the courts are becoming more robust about that now, and they take a much more robust view in terms of whether or not a relationship has truly broken down, and particularly if you've got a large organisation which is able to accommodate somebody. There are lots of staff. You're not necessarily having to restore somebody to a relationship perhaps with one other individual, then the courts are certainly much more likely to accommodate that.
Right.
So you've got that as a remedy. You've also got, certainly under the Fair Work Act, the opportunity to have an order that an offender pay penalties. That may not necessarily be directed to the employee, but it's certainly something which sends a very loud message, acts as a deterrent, and I think sends a very strong signal to other employers.
Paul, do you have something to
Yeah,
add?
certainly there has been cases where they have actually ordered that penalty to be paid to the employee. And I believe there was a case I read recently where the employee received a $61,000 payment
Wow,
in compensation
that's massive.
rather than it going to consolidated revenue.
And there was another one recently where the employee was awarded $25,000, so not as significant, but still a lot of money, and that was in addition to $10,000 in hurt and humiliation, plus an amount for economic loss of over $20,000. So employers are definitely much more exposed under the Fair Work Act, and that's a real bonus.